Yes.
Daily list for motion, item number 1.
Now, these items relating to Mahindra and Mahindra matters, your lordship had recused yourself from quite a number of them, my lord.
Yes, but I think some of them are infructuous.
Some of them maybe, but
Some of them are infructuous. I think you see this serial number 8, because this Sandeep Sharma has been given bail.
my lord.
So this criminal petition 8 is for cancellation of the anticipatory bail application.
Correct.
So this has become infructuous.
So in fact, my lord, I was under the impression that since your lordship had recused yourself, it may
No,
not be
for
appropriate
at
to.
least let us dispose of the infructuous matter.
We can do that. Not a
Infructuous, I will not take up the others. Infructuous matters will take up. We'll just dispose it of. You see, I think item 8 can be disposed of. Then you see again, item 5 is, before that, item 5 is an application for quashing of the anticipatory bail order. Okay. While item 8 is a application for quashing the bail order.
My lord.
So again, item 5 becomes infructuous. Correct, Mr. Yan Manotra? Is it?
There are two FIRs.
Oh, there are two
There are
FIRs.
two FIRs, my
Oh, there are two FIRs.
There are two
Oh, so all of them, okay,
Yes.
different. Okay.
So these two petitions,
Ah.
one is for quashing the anticipatory bail in one FIR
Okay.
and bail in the second FIR.
So similar, I think similar will be in
Yes.
item 1 and 8 also.
Yes, Your Honor.
So yes, my lord. So
There are two FIRs.
two FIRs. In fact, there's a third FIR also now,
The third FIR.
but only against Jakir and two the.
Now, what will you do the next 3 weeks? None of them can be taken up.
So let the appropriate bench be set up. If the next available bench recuses itself, then we may have to take recourse for
I think
transferring the matter to the principal bench also, my lord.
No, it will not be proper.
has His Lordship Justice Nelson recused himself?
I didn't recuse myself. I said I recused myself from only one case.
But then
And
they're all
where
really-
my- huh?
But they're all rising out of the same FIR. That's the problem. Because any order passed in one,
I will have a rippling effect on
correct, my lord. That's why
Law of parity will apply.
law of parity will be
Your
rest
Honor,
by them.
let it-
So
Has Justice Nelson recused himself?
on
No, I don't
order
think he
at
has
least.
recused. I think he can take up.
Let it come up
Yes,
next week. And
Next week?
let
Not a
it.
problem, my lord. Not a problem.
Okay, right. On the prayer of the council for the parties, list the matter in the next week. Item 1, item
5 to 9,
5 to 9,
14, 15.
14 and 15.
Oh, they can have 5 to 9.
14 and 15, this is what? For assisting the APPP. Anyway, next week, 14, 15. Okay.
Deeply obliged.
For admission, item number 2.
Lordship have implemented Deputy Commissioner Siaha service awaited.
30 days not complete, so we'll have to wait.
Yes.
Right. As per office note, notice has been issued to the respondent number 10 on 19/8/2024. However, there is no service report on the respondent number 10. And, besides, 30 days not being over from the date of issuance of the notice. This is a matter on 20,
Okay.
29,
Item number 3.
No, not 20, before, after that, we give 23, 9. Item?
My lord, I am for the respondent number 2 and 3. I seek another 3 weeks time for obtaining instruction and for filing my
What
affidavit.
instruction do you need here?
My lord, After formal notice has been issued to the respondent number 2 and 3, it may be this the second time only.
Okay, you're right. Wait, what is your case, Mr. Counsel, first of all?
Lordship, this is the construction of the Indo-Bangladesh border fencing, Lordship.
Yes, now, you have been given the compensation amount
Compensation amount. Lordship.
in terms of the 1984 Act.
1994 Act.
Now, and those compensations amount have been given to you in which year? 2009-11.
Lordship, yes. Award is approved on 2000.
Now, what do you want in this writ petition?
Lordship, this one.
Now you want that, what? What do you want? You want rehabilitation and
Rehabilitation,
resettlement
Lordship.
in terms of the 2013 Act.
2013 Act.
But
Lordship.
2013 Act came into effect only in 2014. So where is the question of applying the
Lordship.
2013 Act?
Yeah, Lordship, our land was trying to occupy it after 14 years, Lordship. For that
It was
reason.
occupied after 14 years.
Yes, after
When-
after the lapse of the 14 years, Lordship.
When was it occupied?
Lordship, the state have not occupied.
Mr. What?
My
state has not-
Lordship, my position is not yet occupied by the state or the this one central Lordship.
Your possession has not been occupied?
Yes,
What do
Lordship.
you mean? You are still
We are still in the same position. Yes, even though award is given, Lordship, but till today we are in the same lane, Lordship. So after 14 years, they said that the government said that I need their land for the construction of the Indo-Bangladesh border fencing, Lordship.
So you are still living on your land today?
Yes, Lordship. Till today, yes, Lordship.
Still today?
Till today,
So you
Lordship.
have been given compensation for acquisition
Yes,
of the
Lordship.
land?
Yes,
Besides that, you are still in the land.
yes, Lordship. Yes,
So what are you complaining about?
Lordship, for the resettlement, Lordship.
Why? You are still in you are still in possession of your land. Where's the question of resettlement?
Lordship, let the
No, you show me the law. You show me the law. Under
in
the
lieu of the section 24 of the 2013 Act, Lordship.
Yes, section 24 is there, I think. Yes.
Lordship.
24(2), I think.
Lordship.
Give me 24, give me 2013 Act. No. This is the 1894 Act. I want the 2030, the right to fair compensation. This does not help your case. They've got no right.
My lord, in my writ petition, Lordship.
Show me the law. I don't need the writ petition. Show me the law. You see, the facts are very clear.
Lordship.
According to you, your land has been acquired
Lordship, yes.
under the 1894 Act,
1894.
and compensation has been given to you between 2007 and 2009. Correct?
Lordship.
2013 Act came into force only from 2014 January.
Lordship.
And now you are asking for rehabilitation in terms of the 2014 Act. While all the proceedings
Lordship.
under the 1984 Act has been completed. Now you just pack your bags and leave when they ask you to do it. That's all. There's no question of rehabilitation.
Lordship, with due permissions, shall I read, may I read the prayer portion, Lordship?
Please read. No, please don't read the prayer portion. Please read the law.
Lordship.
Please read the law. What does the law say? Please read 24:2.
Sorry, Lordship, I didn't put my this one, Lordship.
Yeah, give him this. Why shouldn't we dismiss your suit? Yeah, you're in petition. Yes.
May I read, Lordship?
Yes, yes, please read.
Clause 1, Lordship, and notwithstanding anything contained in the Act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply. Where an award under the said Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act, as if the said Act has not been repealed. Close to Lordship, notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the Land Acquisition Act 1894, where an award under the said Section 11 has been made 5 years or more prior to the commencement of this Act, but the physical possessions of the land has not been taken,
Or, then
Lordship.
or, that word or
Yes,
is there.
yes, or the compensation has not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it is so chooses, shall initiate the proceedings of such land acquisition afresh, in accordance with the provisions of this Act.
So,
My lord, here or is there, your lordship?
huh?
Or is there, lordship?
Correct. Now, so the proceeding under the LA Act is completed. Once it is completed, there's no question and there's no right for you to apply the 2013 Act for rehabilitation purposes. That's gone. Eh,
Lordship, in that case,
You
lordship.
see, with the money that you have been given
Lots
as compensation, you have got to rehabilitate yourself as per the 1894 Act. You do that. This 2013 Act is not applicable to your case. So you withdraw or I dismiss? What do you want?
Lordship, short date may be given, lordship.
Why?
Because my senior will argue in
Who is the senior?
Asberg Gohai, lordship. Asberg Gohai, lordship. Because lordship, today as per the last order, lordship, the central government, they are supposed to file their affidavit, lordship.
There is no case.
Lordship, and there is also interim order is there, lordship.
Interim order for what?
Lordship, that they wanted to evict from that position, lordship.
You have
Yes,
to go. You have to go. The interim order we will set it aside. Not interim order.
Lordship, in that case, short date may be given, lordship, after vacation, lordship.
Why after vacation? Why not tomorrow?
Lordship, tomorrow's difficulty is there, lordship.
You cannot have your cake and eat it too. You have taken the compensation and you don't want to leave the land. That is what you're playing at.
Lordship, with your permission, can it be on 30 October, Lordship?
Why not Monday?
Lordship, difficulty is there, Lordship.
If you do not come, you see,
Lordship.
the court is not functioning at your dictation or as per your whims and fancies. Interim order is of which date?
Lordship, 21 February, Lordship.
Of
2023. Order dated 21 February 2023, Lordship.
Then why didn't you say so in the very beginning? When things are going against you, you start saying that you need a senior here. What is this?
Lordship, as per the last order, Lordship, the central government, they are supposed to file their affidavit, Lordship.
Maybe. Right. Mr.
B. Chakma, Lordship.
B. Chakma prays that the matter may be listed on another date so that his senior, Mr. S. Borgohain,
Lordship.
can appear in the matter. Next para. The prayer of the petitioners is to set aside and quash the acquisition of the petitioner's lands taken under acquired under the Land Acquisition Act, 1894, hereinafter referred to as the LA Act, 1894. And that the petitioner's lands be acquired under the right to fair compensation and transparency in land acquisition, transparency in terms of the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act, 2013, hereinafter referred to as the 2013 Act. Pusta. The petitioner's case, as reflected in the order dated 23/1/23, is to the effect that the lands of the petitioners were acquired by award number 1 of 2009 and supplementary award number 1 of 2007. Pusta. The petitioners were also paid the entire compensation amount under the LA Act 1894 between 2007 and 2009. Pusta. The petitioner's case is that they are still in possession of the lands which have been acquired by the state, and that in terms of section 24(2) of the 2013 Act, the petitioner's land should be acquired under the 2013 Act. Full stop. Section 24 of the 2013 Act states as follows. Full stop. A perusal of the above provision of law clearly shows that as the compensation amount for the acquired land has been paid to the petitioners in 2007, between 2007 and 2009, it prima facie appears that there cannot be any claim for payment for acquiring the land for which under the 2013 Act. Full stop. However, in view of the prayer of the petitioner that full stop. The entire case filed by the petitioners appears to be to thwart, THWART, thwart the state respondents from taking possession of the lands which have been acquired by the state, for which the compensation amount has been received by the petitioners in the year 2007, between the years 2007 and 2009. List the matter. When? Which date?
Lordship, can it be on 30 October, Lordship?
30 October. 30 October?
30 October.
Why
Lordship.
30 October?
Then, Lordship, your vacation is there, Lordship.
Maybe.
Then,
List the matter.
can it be on 24th, Lordship? 24th October.
List the matter on 24 September.
Lordship, 24th October, Lordship.
24 September. Next.
Lordship, interim order to be continued,
No.
Lordship.
Item 4.
Obliged, Lordship.
This court is not inclined to extend the interim order in view of the reasons stated above.
Please, Your Lordship, respondent number 1 to 4 is not yet filed their so-called reply. Only respondent number 5 has filed. And in the meantime, Your Lordship, respondent
Item number?
item number 4.
No, Madam, please come to the affidavit of the respondent number
Yes,
5.
yes, I have seen that. Your
Then
Lordship.
what remains?
The thing is that I have inquired about it. They have no knowledge about this.
Who doesn't have knowledge?
The concerned minister also.
No, that is a different thing. They don't have knowledge that it's already here in black and white.
Yeah, Your Lordship,
So
in
we
the
will-
meantime, let at least...
No, you see, madam, let us be very clear. That as per the last order also, as per the last order, 27/8/2024, Mrs. Dinariti, as you learned, so prays that she may be given a week's time to obtain instructions with regard to the contentions raised by the director. So in the affidavit, so praise aloud, this is matter after a week.
Yes,
Now, this is nearly more than 2 weeks now.
yes, Your
Now,
Lordship,
out here, what is the order passed? The order passed is that accordingly, the state respondents are directed to consider regularizing the service of the members of the petitioner association against the existing vacant posts of government teachers in the appropriate grade, keeping in mind the experience and training undergone by the members of the petitioner association and the object and mandate of the RTE, or in the alternative to sanction new posts as SSA teachers. It would also be open for the state government to frame a scheme providing for further terms and conditions on which such regularization shall be done. Now it has been done. Now, if you're not happy with this, you can file a writ challenging this.
no,
Otherwise, you say that
I'm happy with that.
Yes, if
The
you're happy
thing
with
is
this,
that, Your
has to be
Lordship,
complied with this.
the affidavit is filed by director only.
So, no,
So,
madam. Affidavit is filed by director, but the scheme is made by the state of Mizoram.
Yes, Your Lordship, in the cabinet meeting, and what they have mentioned is that we are excluded. Yeah,
Clarification has
they
been given
are
that is
clarified, but it's what it's about is that the lordship is a director only. Let at least
we'll clarify that. We'll
yeah,
clarify-
DPNR is there, finance department.
we will clarify that. We will clarify that. Right. Heard Mrs. Dinariti again. Learned counsel for the petitioners. Also heard Mr.
Jonathan Larin Kluanga,
Jonathan Lalin Luanga, learned counsel for
the respondent number 5.
point number 5.
2 and 5, Your Lordship.
2 and 5. Pusta. The present
Your Lordship, kindly see the judgment. Kindly see the judgment.
yes.
Para 23.
Yes.
Yeah.
Yes.
Thus, Regarding the Lordship, page 47 of my petition. Thus, upon due consideration of the case in its entirety, I find that the grievance expressed by the petitioners' association to be legitimate and has merit. Accordingly, the state respondents are directed to consider regularizing the services of the members of the petitioners' association against the existing vacant posts of government teachers in the appropriate grade, keeping in mind the experiences and training undergone by the members of the petitioners' association, and the object and mandate of the RTE Act, or in the alternative to sanction new posts as SSA teachers by creating such cadre. It would also be open for the state government to frame a scheme providing for further terms and conditions on which such regularization shall be done. Such an exercise should be initiated and completed within a period of 6 months from the date of receipt of the certified copy of the order. So I agree that now they have made the scheme, Your Lordship, but the regularization is not yet done. The scheme is for all the CSS employees, as you know, Your Lordship. So what I'm worried
When are you
about,
going to start the regularization process?
they
Lordship,
cannot say that.
I have not received any instruction on that regard, but in order
Because
to,
you have made the scheme,
yes.
which is to be made applicable to the
Now they
petitioner.
are collecting the list of teachers who are applicable. The list is being prepared.
This scheme is for all the CSS,
How
including
many are there?
teachers.
How many are there?
There's NREGS, DRDS, how many CSS employees in Mizoram? So for all together, they have made one scheme, not for only teachers. So I'm doubtful that when they are going to regularize, just making the scheme is not suffice.
Your Lordship, the order does not mention specifically that SSA teachers should be given priority.
Yeah,
It
they
mentions
have-
that, or in the alternative, to sanction new posts such as SSA teachers by creating such
So
cadre.
the regularization,
So-
when they'll start, if they can say that,
As-
they'll start in the
As per my humble
immediately,
opinion,
you
the
have
order
no
has been
problem.
complied with. As per my humble opinion, the order has been complied with by
No, the
formulating the scheme.
regularization is not done.
Regularization will be done based on the scheme.
When? That is the question.
That is the up to the government to take up.
That should be reported to this one.
And Your Lordship, in order to facilitate the first portion of the paragraph, the second portion has been put into operation. So the regularization will also come into effect as soon as possible.
6 months given all the exercise, Your Lordship, reading the judgment. Lordship, my humble prayer is that at this stage, let the secretaries file the affidavit when they are going to regularize the present petitioners in compliance with the judgment and order passed by this honorable court.
Okay, what have I said? Heard, Mister? Heard, Miss? Okay, right. The present contempt petition has been filed for alleged non-compliance with the judgment and order dated 17/3/23, passed in WPC 128 of 2019, which at para 23 states as follows, page 47. Next, the respondent number 5, who is the director from a school education department, has
Your Lordship, if I may add, he is also presently holding the position of State Project Director.
how does that matter, Mr. Counsel? The one who is the director has been made the thing, has been made a party.
Oh.
Might be the director of industries also. We cannot put everything here. What have I said? Has submitted affidavit dated 22/8/24, which is to the effect that in compliance with the judgment and order dated 17/3/23, passed in WPC number 128 of 2019, the state government has published the Government of Mizoram Regularization of Centrally Sponsored Scheme bracket CSS bracket close Employee Scheme, 2004, which came into effect from the date of publication in the official gazette, that is 18/6/2024. The affidavit of the respondent number 5 states that the above scheme would also be applicable to the petitioner's hearing. First start. This is the matter. After 4 weeks, to enable the parties to make submissions as to whether the judgment and order, to make further, to enable the parties to make further submissions in the matter.
Matthew.
Item number 10.
My Lord, for the respondent number 1 to 3, 3 weeks time, 4 weeks time may be granted for filing affidavit in opposition.
What is your name, madam?
Vanel Swami.
What is this for? Item 10.
Yes, my Lord. Item 10.
Here for item 1, 2?
Item 10, respondent
Yes,
number
for the
1 to
report.
3, all the respondent.
Okay. This is, you remove them from, was there any inquiry taken?
Yes, my Lord.
The inquiry were taken.
Yes.
The departmental proceedings were initiated against the petitioners or not? You have got no idea.
Though Parawai's comment had already sent, we have not yet received the supporting documents. Though,
Okay. Miss Vana Swami, Learned Counsel for the,
respondent number 1 to 3.
your name is not here, madam. You are appearing for whom? Who's your senior?
That's Liana Kyangte.
Okay, Miss Vana Swami appearing for Mr. Lalchandana Kiyanko. Counsel for the respondent number 1 to 3 submits that parawise comments have been received from the respondents. However, supporting documents have not received by them. Full stop. Last chance is given to the. Will it be last chance? Okay, right. For 3 weeks time is provided to the
My Lord,
respondents number 1 to 3 to submit their affidavit.
4 weeks time may be granted.
4 weeks time. Okay, 4 weeks time is granted to file affidavit in opposition on behalf of the respondent number 1 to 3. This is the matter out of 4 weeks.
Orders item 11 and 12.
Your Lordship, if 1 week's time may kindly be granted for obtaining instruction for filing my objection, Lordship.
This is a law point. Yes, this is a anticipatory bail petition in a NDPS case.
Yes, Your Lordship,
No.
this matter is,
I'm not allowing this.
Your Lordship, this matter is handled by senior advocate.
Then let
Mr.
him
F.
appear. Let him appear virtually or whatever. I'm not allowing this.
Today, he has some
Tomorrow
difficulty.
then. If he can appear virtually. If he's not appearing, I'm dismissing it. You can go and ask for bail in the proper court. What is this? Anticipatory bail in an NDPS case.
Each,
There 2.5 kg heroin has been seized.
yes, Your Lord.
Standing warrant of arrest. Why? Charge sheet has been filed.
No, my Lord. Yes, as of now, trial has now begun, my Lord.
He is a absconder.
Actually, he earlier was not arrested, Lordship.
Is he an absconder? Is he an accused? What is he? Why is he asking for anticipatory bail?
Actually,
You don't know the facts of the case.
Actually, I am not appearing in the trial court, my Lord. That's appropriate.
Mr. Counsel, you have got you are handling the anticipatory bail application. You have got to know what is the facts of the case.
My Lord. Actually, 2.5 kgs of heroin was seized on the way from some
Mr. Counsel, there is one simple thing. Why has this person asked for anticipatory bail?
He was the supposed receiver, Lordship.
Supposed to receive.
He was contacted. Yes.
So has he been made an accused in this case?
As of now, Your Lordship, that time.
Please do some reading. We read the case it has come yesterday for the first time, the list. We do the reading. You are handling one case, you should do the reading.
My Lord.
You all don't know the facts of the case also.
Instruction, my Lord. If
This is not instruction, Mr. Counsel, it's here. This petition is here. Please read it.
one problem regarding this case, Your Lordship. earlier these NCB cases relating to Mizoram was handled by Guwahati unit of NCB. But now recent development has been there. Had happened that Agartala unit is handling the case.
Huh?
Agartala unit of NCB.
Mr. Council, whatever
is
it
why
is,
the
you are
officer
the,
have
you are
changed.
the council now. You have been the council for this department since when? Since when were you the council?
Last year, Lordship.
Last year.
October.
So your whole year is there. This case was filed
No,
when? In July.
Yes.
You have got 2 months. You have had 2 months to know about the facts of the case. You can ask
That,
them.
my lord, sorry, my lord.
Huh?
They have not furnished me any instruction regarding this.
You can always ask from the court. The NDPS case is here in Aizawl, in the NDPS court. It is not in Agartala. The office might be there. Your office might be there. But the court case is going on here in Aizawl.
Your Lordship, if
That
we
is
can
not the
kindly
way.
take it up tomorrow,
See,
my lord.
I have been the counsel for various organizations whose offices were nowhere in Aizawl. But that didn't stop me from getting information with regard to a case that is pending in this court. That's your duty, Mr. Counsel. What is this excuses? Are you hand in glove with the petitioners? When you don't know information that is so serious, whole of Mizoram is worried about the number of drugs that is coming in. 2.5 kgs have been seized in this case. It's a serious matter.
Exactly, Lordship.
Then please use your own initiative. Don't wait for things to come. It's like you have to be spoon fed. You have been an ex additional AG. You should know your responsibility.
My lord, I know that, but regarding this,
Tell them to come. Tell your officers to come.
if, my lord, if it may kindly be taken up tomorrow, in the meantime, Lordship, I'll obtain instruction on the detailed cases. And also, my lord, there is also one technical issue which I'd like to raise.
Huh?
Lordship. One technical issue, Lordship, regarding the invoked application of 482, this BNS. This, my lord, would not be applicable at the time when this transition period has happened, Lordship. So for that also, my lord, if this may kindly be taken up tomorrow, if it Lordship.
Yes, what is the case? Charge sheet has been filed.
Yes.
Then are you an absconder or what?
No.
Then why are you filing an anticipatory bail? What is the apprehension?
Lordship, though I'm not the leading counsel, I can just brief explain it. He was on the accusation of the co-accused who was arrested. He was made as an accused. So on apprehension of arrest, he has applied for anticipatory bail. And
In the charge sheet submitted, where is the charge sheet? Charge sheet has been submitted or
No,
not?
my lord, submitted, but
Charge
in
sheet
the
is in the
first
file.
charge
In the
sheet,
charge sheet,
he was
is
not
he an
arraigned as an
absconder?
accused.
Is he an accused?
he is an accused in the
He is an accused in the charge sheet.
yes.
And what is the allegation made against him?
Allegation is that
He is going to receive the goods.
that is the allegation of the prosecution.
intended
And then-
by your lordship.
and position and the seizure was made in the way from Champai, from the position of the other accused.
We'll take it up tomorrow. You tell your senior to appear. He can appear virtually also.
Obliged, your lordship. And regarding item 12, your lordship, here I have to file affidavit of objection, lordship.
Okay,
For
right.
1 week time, my lord. 1 week
In
time.
item 12, you write, Mr. C. Zoram Thana is granted a week's time to file written objection. In item 12. Huh?
12, yes, lordship.
In item 12. Then in item 11, you write, list the matter tomorrow.
Obliged.
Item number
Your
13.
Lordship,
What is this item? 13. 13. Right, in the main case. Uh, Registry to send a reminder for the LCR, for the original LCR. Not for the LCR. No, this is the case is going on.
My lord, no, it was disposed of.
It's in this court. Okay. Now it's here. To send a reminder for the LCR. Yes. Who is the query for the respondent?
My lord, not yet. CBI. My lord, last time you rectify your own order to be listed on after a week. So it was.
Yes. Now, what to do?
My lord, may I please allow? Yes, humble a request I have.
What?
My lord, today yet it was listed before also. So I have a long list of compilation of my the judgment at this stage. So as of 19 judgment, wherein your lordship also, without issuing notice in CBI case in Judy Order 23-2, also after admissions of the appeal, suspend the sentence, not the conviction. My lord, this time I'm not praying for suspension.
There is no question of suspension of conviction.
Yes, lordship. I'm
That
praying
cannot
only.
be done.
So, my lord, here, if you allow, all of them are without issuing notice. Okay.
No. Are all the other co-accused, have they been released?
My lord, two of the co-accused were acquitted. Only two accused were convicted, and the main accused was already released. I have enclosed in Annexure 2 also.
No, you are the main person.
My lord, also might be.
You are the main person.
My lord, I enclosed in Annexure 2.
What is happening? Who is the CBI? Is
My
they
lord-
having an office out here?
My lord, actually they have office, and also they have two standing counsel in district court, special court. But even before also, Zahid and Sangpui used to appear in another matters also. But now recently, they floated advertisement.
And where is the advertisement? Let us see.
My lord, it is, no, they put on the bar group also in the notice board also.
When is the last date of submission of the application?
29,
29.
yes.
20.
Yeah, yes,
20.
209, 2024. But after lots of formalities used to be they used to have in CBI case.
How many were convicted? Two were convicted.
Two only, my lord.
And the other one has been released.
Already released. Without issuing notice also. That. My lord, page number 18.
Look, one thing, the PP, you should know one thing. There is no provision for suspension of a conviction order. I find there are sometimes orders are being passed that conviction is suspended. It's only the sentence order that can be suspended. So please tell your other additional PPs also. Otherwise, we are committing, and we are passing wrong orders. How long has he been in jail?
So far, it will be around 70 days, because he was convicted on first 2024.
He is from where? Where is his address?
He is Lamka, Churachand address.
Have you served a copy of this petition to the CBI office out here?
Yes, we have taken step as per your direction, Your Lordship.
No, that step is as per registered post with AD. That will take time. We'll list this matter tomorrow. You give a copy of this order to, you give a copy of this order and this application to the CBI office here
Yes,
in
Lordship.
district court.
Yes.
And we'll see. Right. No one appears for the CBI. Full stop. As can be seen from the order dated 2/9/2024. Notice was issued to the CBI by a registered post with AD on 6/9/2024. Full stop. As it has been stated at the bar that the CBI has issued an advertisement for appointment of a PP. And the fact that, while the fact remains that there are CBI counsels in the district court, the appellant shall serve a copy of this order along with a copy of this petition to the CBI office in the district court and submit proof of the same. Is the matter tomorrow or when, next week or when do you want?
Well, tomorrow is actually my flight. Like, if it can be listed at the earlier item.
You
Or at least-
mentioned it, we'll take it up at item 1.
My lord, also there is notification that the one who took up bail in respect of the FIR should be handed by the same judge. There is
No.
or it can be taken.
Those are for
And also Monday, Justice Marley will be coming on Monday. Can be listed on Monday also,
okay.
so that the order will be
Yes.
uploaded.
Okay.
Then we can serve copies to the
ठीक है,
office.
list the matter on Monday. Monday
Sir,
holiday.
can you specific, sir, that before
Monday
the
is
judge-
holiday.
Oh, Tuesday?
Tuesday.
Can you specify the judge lordship?
No,
Okay,
the
fine.
registry.
Yes.
The only thing is that I don't find any ground not to allow. Only problem is there's no CBI. That's the problem.
Well, I furnish one citation also. You exactly say that right to that one, they don't have any right to suspend the conviction. Also today, that to 1999, only to the sentence they can, and that the judgment I furnish 2 times they have gone to Supreme Court and second round also. That is the version of this is the law.
Anyway, only problem is the CBI council. At least the district court CBI council can appear also.
Yes, of course. Even central government council used to appear in some other matters also. I don't know, this time they changed their system.
For hearing, item number 16.
My lord, how can we execute proof of the same in that respect?
Huh?
Proof of the same, how can we execute?
You file an affidavit.
All right, thank you, Lordship.
Prove the same by filing affidavit. Along with you make this thing that you say okay. So what have I said? Please read louder. I can't hear you. Too much there. The petitioner shall serve copy. The petitioner is also allowed to serve notice by way of dusty service to the respondents through the CBI office and through the registry of this court to the CBI office in the district court, or to the CBI councils to the CBI office at the district court or their councils. Affidavit of service should thereafter be submitted.
Much obliged.
Yes, next. Yes.
Lordship sees to get the information.
Hmm?
Sees to get the information instruction.
Yes, madam.
My lord, regarding the grants are the 30 lakhs and under the 12 Finance Commission, my lord, we could not find the files, necessary files. The ZITCO has no knowledge regarding that. And the
ZITCO will not have.
Yes, commerce
If
and
you know, but
industries
ZITCO has taken the money from whom?
from the, I think from the Commerce and Industries Department.
There has to be some paper trail. Money doesn't
And-
just suddenly
Yes,
appear.
Commerce and Industries Department, they are not sure. So they have went to the Finance Department to look at the files, but they could not find the necessary files. And Finance is not a party in this case, so.
No, madam. His case is that it came from the Bamboo Development Agency money from buffer courts. How come they don't
Buffer
have?
course,
Yes, from buffer courts.
yes.
So if it's from buffer course, find out. You see, there is a. Please take today's newspaper. I think Wanglaini or Aizol Post. In the editorial, there is a thing regarding the money, regarding buffer cost. It is there. Please keep it with you. It was a special grant, something like that. It was written. So what to do?
My lord, in my writ petition at Para 2, I clearly stated that the money was coming from buffer courts, which they did not deny.
No, which day?
They did not deny.
Yes, that is true.
Okay, he has not
from
denied.
buffer course, no.
Then the thing is that whether it is a grant or not, how do we know?
That's what.
How do we know that, whether it's a grant or not?
My lord, all the money
Is there
that-
any official document showing whether it is a grant or not?
Yes, my lord, in my rejoinder affidavit. At the last page. Has the central disbursed the 12 Finance Commission to the Mizoram government as a 100%?
No, no, with additional affidavit or additional rejoinder affidavit?
Rejoinder affidavit.
Additional.
No, rejoinder affidavit.
Yes.
The information that we get through RTI. So, my lord, has the central disbursed the 12 Finance Commission to the Mizoram government as a 100?
Para. Last page.
Last page, my lord. Annex 3A, page 14.
Yes.
Has the central disbursed the 12 Finance Commission to the Mizoram government as a 100% grant or loan? All grants received under the 12 Finance Commission were disbursed as a 100% grant.
And what do you mean by the grant? Grant is not a loan.
Not a loan.
Where, how do you know that? Where, how can you say that?
All grants
Or a loan, okay, as grant. Okay,
yes,
as a-
as grant, 100% grant.
Suppose just because the central government has given to the state government this amount as a grant, does it mean that it has to be used as a grant only?
But my lord, they did not sanction the third phase to me, and I face the problem.
Supposing it is still a loan. Supposing the state can give a loan,
Yes,
then you'll have to pay back the loan.
yes, I have repaid 11 lakhs.
You'll have to
10,000.
pay the entire amount without the interest.
But my lord, they did not give me the third phase.
Maybe, but supposing out of 100 rupees they gave you only 70,
Yes, my lord.
you have to give back 70.
But my lord, I cannot finish my business without that loan, that third phase.
Maybe, so that is why you're not going to pay interest.
But similarly situated person with me in the BDA, they have been
given-
waived.
They've been waived.
Yes,
Where is that? Where is
At
that?
my additional rejoinder, my lord.
Yes. Yes, where?
At the last page,
Yes.
Annex 3.
Yes.
Inviting reference to the above, I am directed to convey government approval to the resolution taken by the 21st General Body Meeting of Bamboo Development Agency, which resolved to waive loan granted to 9 of the bamboo chipping units for further necessary action.
Okay. Now, who are these 9 bamboo chipping units? Who are they?
My lord, today I was given by the zone website, and it was in the loose form. There are 9 of them, my lord. And out here also, number 1, sanction amount was 70 lakhs.
Just a minute. Out of 9 number of units, 7 numbers are fully assisted from buffer cost, whereas 2 units are given assisted from a side scheme. The financial assistance given to them were loans which are below the shipping clusters. So you are
Lallura.
Lallura, Petra.
Out here also,
Lal
they have-
Nora is not here.
no, they are the 9 chipping bamboos,
Huh.
which was, their loan have been waived.
Correct. So you are not included here.
That is why, my lord, I have approached this court.
Out of the 9, only seven have been given from buffer cost.
These are the people those BDS given.
You see, the financial assistance given to these entrepreneurs were as loan, against which agreement was signed between member and each of the entrepreneurs. Okay. Now, were as loan, and there was an agreement signed between BDA.
Yes.
You don't have any agreement with BDA.
Yes, my lord. I am those similarly situated person, those who get that money from the buffer cost 12 Finance Commission, their loan has been waived off. And they are also similarly situated like me, which they have not been fully paid their loan amount.
No, why not the entire thing? Why only one extract? You will the entire document.
They don't have, my lord. That's all. I asked
This is nothing,
this
there's no
person-
signature, nothing, no official. This cannot be accepted. It has to have some letter number, memo number, some date, something, who has signed it. This cannot be, this can be made by anybody.
But my lord, but the BDA, they had informed to the undersecretary at my additional rejoinder, additional affidavit.
I think you both have to look at today's paper, Wanglaini or Aizol Post, one of them, with regard to this payments. And there's a thing called, there's a small portion of it on buffer costs. Please read it. Very difficult, Mr. Counselor. Because here the issue is payment has been made from BDA. I think.
My lord, like if a meeting can be organized by the respondent number 1, 2, 3, and ZIPO to be like a this my read petition at page 25. Let them also have a meeting considering all these aspects.
Page 25 or read petition?
25 of my read petition.
I don't have any page 25. Or is it loose paper?
In my read petition.
Is it loose paper? Oh, okay. It's chill, right? No, you see the problem is these persons, 9 persons have been given loans through the BDA. You have been given loan from the ZITCO. That's different.
But the money which they have get is from the,
Maybe we do not know.
so my lord, let this court constitute the committee and let them consider my case, my lord.
I don't know what to do, madam.
My lord, these are two entirely different things. One is related to Bamboo Development Agency. And here we are concerned with
Because
ZIPCO.
my lord, respondent number 1, 2, and 3 are the same.
They have received this fund as shared capital contribution from the state
Give
government
this,
under
give
buffer
this
post.
back. With nothing. Cannot be. We'll adjourn the matter. We need to think. You need some more information. You find out, madam, whether it's from the thing, whether it's from the buffer cost scheme or not, the money.
It's
How
from
come?
buffer
How come a
course.
bank doesn't know where he gets his money from? They have to. All money has a paper trail. It is not given in cash like Chiapom or something. It is given by way of electronic transactions.
My lord, we are aware that we received these funds from buffer course.
You received
Yes.
from the buffer cost fund.
Yes, a shared capital by the ZITCO.
No, I think
So
you'll look at. I have not looked at it properly. Today's document paper. Just look at it. We'll see. This is the matter. After in the next week or after in the next week.
After vacation, my lord.
Huh?
After vacation,
Why?
any time,
Huh?
any convenient time.
This is the matter after 2 weeks to enable the Respondents Council to obtain further instructions in the matter.
Hearing list, item number 8.
Very please, Your Lordship. My Lord, this is an appeal directly against judgment order dated 28/7/2022. My Lord, the situation in this is that we were completely unaware of the case of the title suit that has been filed in the lower court. Apparently, some summons were issued, but we never received any of those. And in regard to that issue, I'd like to take Your Lordship to the lower court records, the order of the lower court record dated 19/7/2016.
Page?
The lower court
There's a
records.
paper book. Paper book is not
It's
there.
not the
Show me
the order of the court is not in the paper book.
Show it the lower court report.
Order sheet.
Order sheet.
Order sheet dated 19/7/2016, my lord.
19/7 2000. Page
I don't know the page, my lord.
19/7 2000.
19/7/2016.
Yes,
Yes. Plaintiff and defendants number 1 to 4 are present through respective learned counsels. While summons returns shows that it was not.
it was served.
It was served to defendant number 5 but failed to appear in court. Defendant number 1 to 4 submit written statement with copies for plaintiff and defendant number 5. With this, defendant number 5 is the only party who has to file the WS. Issue summons to defendant number 5, Vantuoma, son of Rosika, resident of Dorpuiveng, Aizol, to be served by plaintiff. Fixed 11/8/2016 for WS by defendant number 5. So, my lord, even though the order sheet stated that summons had been returned, it had specifically asked the plaintiff to take steps again against the.
Correct.
But we have not received any summons. Nothing has been received by us. And suddenly, in the year 2022, we were made aware of the judgment and order. We were just served a copy. And that is the extent of our knowledge with regard to this land dispute. And so, my lord, we have come in this with regard to this judgment order. And my learned friend had raised the issue that this appeal is barred by Order 9, Rule 13. Ex parte order is saying.
Order
my
9 Rule 13 is for
Exactly,
setting
my lord.
aside an ex parte order.
My lord. And not ex parte decree, my lord. And this we were made ex parte by an order, not a decree.
Huh?
So
You
we're
were
saying
you were made ex parte
my lord.
by the court.
by the court,
Ah.
by an order, not a decree. So we're stating that we have every right to come in this appeal. So this order,
On perusal, yes, yes, Mr. JC.
No, actually, it is the judge who raised that you have not challenged this order. So without challenging this order, so you cannot straight away challenge to the main appeal. This is the query, and also he was given liberty to look for judgment research.
No, no, he has not challenged the impugned order.
Yes, no.
Impugned judgment and order and decree.
Yes.
He has challenged.
He has challenged the impugned order, but he has not challenged that order, passing ex parte order against him. That we just-
But now he's saying that it has been done ex parte. The main case, all the earlier orders,
Yes.
they merge into this final order. That is the law.
Yes.
When any interim orders or any orders are passed earlier, they merge into the final order. That is the law.
Yes. Then.
It's like this. Supposing there is an interim order passed against for the petitioner, and in the main case, we say dismiss the writ petition. We don't have to specifically state that the interim order is set aside, because that automatically gets merged into the main case, into the main order. So out here also, it gets automatically merged.
That's
because
it.
I think I'm
So
quite sure.
the court directed to look for judgment. That's why because of that now the hearing was adjourned. So
Okay.
we have come this much.
Anyway, let me see. 122 141 141 122 144 122 141 122 141. Okay, at page 126. He was not aware of this order. But yes, you should have made a challenge to this order by way of abundant caution. Why have you not challenged this order? 2/11/2016.
pardon, my lord, because
Please turn to, you've got the paper book with you? Paper book,
I
you've
have,
got, page turn to 126,
para number
para
6.
6.
my lord.
Then, but you file an amended, you file a application for amendment of the appeal petition.
My lord, he challenged at the very first appeal against, but at least he might have to file condonation of the. If you kindly see,
No.
If you kindly see the
Let me
memo.
see this 2/11/16. 2/11/16 order. 2/11/16. Where is it? 2/11/16. 2/11/16. But how did the trial court, you see, in your, you were the plaintiff was to it issued summons to the defendant number 5 to be served by the plaintiff. Where is the service of the notice by the plaintiff?
My lord, out of my knowledge, because in the trial court they just kept it, and as of now I have not seen. But the orders reflects clearly that someone was served.
No, say that. But then, you see, out here someone was served as per someone's return shows that it was served. That
Yes.
was at 1907.
Yes.
That being said, again notice was issued. Issue summons. So once again on the same order, notice was again issued.
Yes.
Despite saying. So now that means impliedly that a fresh notice had to be served upon the appellant. Now that fresh notice, where is the service of the fresh notice? Nothing is mentioned. There is nothing in the records. Let me see the record.
As a practice, we normally challenge this kind of ex parte order.
Yes, why don't you challenge it? Make an application for amendment. That's all.
Well, if you kindly see page number 143 of the paper book, he challenged here an appeal against ex parte order dated
So he challenged it.
No, it in this the same one.
Page
143.
143. An appeal under section 1 against the ex parte order. That is when. Okay.
But this it was barred by limitation, and also at the last that in the pleading also did not state anything, and also in the prayer portion also did not specifically say anything, just kept quiet again. If you see the prayer portion,
No. So what happened to this RFA 39?
yes,
This is 39.
yes,
So he has made a challenge.
but
But what you are saying?
if you see the prayer clause 148,
148.
only praying for setting aside of the main judgment 28/7/2022.
Anyway, it gets merged into this, that order gets merged into the final order. What is wrong?
Yes,
There's nothing wrong when you think of it that way, because you see, like I said, if in a final order, all the other orders get merged. Say in a writ petition, when an interim order is issued in favor of the petitioner, and we dismiss the writ petition later on, we don't have to say that interim order is set aside, because it is understood that the interim order also gets vacated by the final order. So here also, the ex parte order gets merged into the final judgment.
my lord, if you file amendment application,
I know that's better, safer.
yes, safer.
Why don't you file an amendment just to set aside the order also,
My lord,
by way of abundant caution? Yes.
that order has been confirmed by the final judgment and order at
Yeah, where?
para number 6, my lord.
Para number 6.
My lord.
Page?
126, page 126.
It is just reiterating. Where is it confirmation? It is reiterating what has been said earlier.
My lord. Therefore, the order dated 2/11/2015 is a part and parcel of the, because of this reiteration. Hence, the word hence. Hence, the court by judgment and order date 2/11 proceeded ex parte against the defendant number 5.
Correct.
So, my lord, this order dated 2/11/2015 has been made a part and parcel of the judgment and order only, my lord.
So
By-
you no.
by this-
No. But one thing is that it's very clear that order is there. Why is it so difficult for you to make a small amendment?
That can be done also.
Just make an
But my lord,
amendment.
that would only that would only serve the purpose of wasting some more time, my lord.
So
Because,
what?
this
But the
matter can-
sometimes the procedure is there. So by way of abundant caution, see in the future also, at least you have because the orders of 2/11/2016. You just say that amendment of the prayer portion.
and also, my lord, it has also been mentioned in the cost title, my lord.
What?
Cost title. Cost title of the
So what? But there's no prayer. This is not a writ petition.
my lord.
My lord, one thing, just if we can simplify the matter and we can somehow dispose of as this matter also. This suit is very simple. My pass was in issue in 1987. Their pass was issued in 1914. And that 2015, the plaintiff filed a suit. And the prayer is that for
Who is the plaintiff? You are the plaintiff.
I'm the plaintiff for cancellation of their pass, for also for eviction also. But in the last prayer, the prayer portion is that if the state government cannot direct them for vacating the land, and he claimed only 40 lakhs. And 2015,
He claimed only 40 lakhs.
40 lakhs. In 2015, the suit property was the market value would be around that 40 lakhs. Now it's almost 10 years. Now it has really raised. But as of now, if the prayer is also allowed also, as of now, he cannot extend it also. That at this 2024,
No, you see, the only thing is that if he's not allowed to participate in the proceedings, it has to be remanded back. That's all. Nothing else.
and also, sir, Your Lordship, one issue is that it is settled law that in Mizoram, the senior LLC would prevail. Your Lordship also passed judgment.
Correct.
And also this was preferred in SLP also, it was dismissed, Zampui. And I have also judgment. Your Lordship also passed that silo, I have the judgment. Saiziki silo.
Anyway, so whoever is senior,
1987 mine.
yours 1980,
Yes.
his LSC is
2014.
But my lord, we have been in possession of the land since
My
1990.
lord, it might be possession, doesn't give any right.
Possession doesn't give any right.
Previously, it was a VC pass,
VC pass.
my lord.
But whose VC pass was earlier in time?
Pardon, my lord?
Whose VC pass was earlier in time? Whose VC pass
I
is
think we
older?
bought it. I think we bought it from the same person.
No, my lord.
You have bought the land from same person.
My lord, it in their memo of appeal, they at
Pass number, same number.
no, they did not mention anything such kind of number and all. They just this is their contention only. But as far as land settlement certificate was allotted, were allotted in
So there
19
is no house pass, there is no VC pass, nothing.
yes. So there is no even
And,
in their
because
Because
petition
we were
also-
not aware of the proceedings
No,
of this
you
case.
tell
my
me,
lord.
what was there any VC pass or something?
We had a VC pass, my lord.
Anyway, you make an application for amending that portion. Just say for amendment of the prayer portion by adding this prayer for setting aside the order date itself. So that's all. That's all. Then we can decide. Otherwise, he's correct. It's slightly problematic disposing it. As Mr. Valalhaq, learned counsel for the appellant submits that he would like to file an application for putting to for amending the appeal by amending the prayer portion of the appeal for setting aside the ex parte order dated 2/11/2016 passed by the trial court. Leaves the matter after 2 weeks. Will you file it in the meantime?
Sir, for that continuation of delay also might be required.
No, not required. Not required because the entire thing has been allowed. Continuation of delay again. Maybe. Maybe.
Yes, because from the at least from the date of knowledge.
Maybe. Yes.
Yes.
You file that also.